Hello, everyone, and welcome to a special edition of EdPodia CA Discussion. I'm Anisha.
And I'm Karan. Today, we are moving beyond the headlines to look at the very check and balance system of our democracy. We are dissecting the offices of the governor and the lieutenant governor, or the LG.
Many see these as purely ceremonial roles, but in reality, they are the constitutional glue that holds the relationship between the union and the states together. From appointing chief ministers to pardoning sentences, the scope of their authority is vast and deeply rooted in the letter of the law.
Let's start with the Manual of Appointment. Under Article 153, the Constitution says there shall be a governor for each state. However, the 7th Constitutional Amendment Act of 1956 introduced a flexible provision. The same person can be appointed as governor for two or more states simultaneously.
And who chooses them? Under Article 155, the governor is appointed by the president. It's important to note that the governor doesn't have a fixed tenure in the traditional sense. Article 156 specifies that they hold office during the pleasure of the president. While a 5-year term is standard, the president can transfer or remove them at any time.
To be eligible under Article 157, you must be a citizen of India and at least 35 years old. But Article 158 adds strict conditions. You cannot hold any office of profit, and you cannot be a member of parliament or any state legislature. If a sitting MP or MLA is appointed, they must vacate their seat immediately.
Now, let's talk about what they actually do. Under Article 154, all executive power of the state is officially vested in the governor. This means every government order is technically issued in their name under Article 166.
Their most visible duty is under Article 164, where they appoint the Chief Minister. They also appoint the Advocate General under Article 165 and the members of the State Public Service Commission.
In the legislative sphere, the governor is a vital part of the state assembly. Under Article 174, they have the power to summon, call a session, prorogue, end a session, and dissolve the legislative assembly. If a law is needed urgently while the assembly isn't meeting, Article 213 gives them the power to issue ordinances, which have the same legal weight as a regular law.
And we can't forget Article 200. When the State Assembly passes a bill, it must go to the governor. They can sign it, send it back for changes, or, most significantly, reserve it for the President's consideration.
There is a heavy financial responsibility too. Under Article 202, the governor ensures that the annual financial statement or the state budget is laid before the legislature. Crucially, under Article 203, no demand for a grant, a request for funds, can be made in the assembly without the governor's prior recommendation.
On the judicial side, Article 161 gives the governor the power of mercy. They can grant pardons, reprieves, or remissions of punishment for anyone convicted under a state law. While they cannot pardon a death sentence, that remains the exclusive power of the president. They can commute or suspend it.
Now, let's switch to the Union Territories, UTs. These fall under Part 8, specifically Article 239. While a governor is a constitutional head of a state, an LG is an administrator appointed by the president to govern a UT.
Delhi is the most complex example. Article 239 AA gives Delhi a special status. It has an elected assembly, but the LG retains direct control over public order, police, and land. To clear up common confusion, the Government of NCT of Delhi Amendment Act 2021 was passed by Parliament. It explicitly defines government in Delhi as the Lieutenant Governor, meaning the elected cabinet must seek the LG's opinion on many executive decisions.
Over the years, the Supreme Court has set limits to ensure these offices aren't misused. In the S.R. Bombay case, 1994, the court ruled that the governor's recommendation to impose president's rule under Article 356 isn't final. It can be challenged in court if it's based on bad faith.
Similarly, in the BP Singhal case, 2010, the court said that while a governor can be removed at the president's pleasure, it cannot be done for arbitrary or political reasons.
Even the Sarkaria Commission and Panchi Commission have long suggested that governors should be eminent outsiders to the state to maintain neutrality, and that they should be consulted with the chief minister before appointment to ensure smooth governance.
Whether it's the Article 159 oath to defend the Constitution or the Article 361 immunity from criminal proceedings, the office of the governor is built to be a pillar of stability in our federal structure.
We hope this detailed breakdown helps you understand the complexities of our administration. It has been a pleasure deconstructing this with you, Karan.
For more in-depth explorations of the Indian Constitution and its impact on your life, make sure to subscribe to EdPodia In.
And please leave your valuable comments and questions below. We love hearing your perspectives on these topics.
Until next time, stay curious and stay informed. Goodbye.